And my first guest tonight is the lawyer for the Gandhis, senior lawyer, four-time MP of the Congress Party, Abhishek Manu Singhvi joins us. Appreciate your joining us, Dr. Singhvi. It appears that while a Delhi court has dismissed the money laundering complaint registered by the ED against the Gandhis in the National Herald case, the court has also made it clear they are not pronouncing on the merits of the case. So is the celebration in the Congress premature that the Gandhis have been let off? Because that is not quite the case.
You judge for yourself, Rajdeep. Let me put it in perspective for your viewers. The judge has refused to take cognizance of the complaint. Cognizance is the lowest form of entertaining something. He has thought it not fit enough even to take cognizance, which is the basic entry point. Point number two, he has in effect said that there is no predicate offence, the underlying main offence, which is the dog, without which the tail cannot wag, because the ED is always a consequential offence. So, in the absence of a FIR, which is what the judge has found, there is no consequential ED offence made out. Point number three, the result is that for the last 2-3 years, with 50 hours of interrogation of Rahul Gandhi, with 10 hours of interrogation of a lady like Sonia Gandhi, with all this hullabaloo every day in the press, shooting through every possible channel and newspaper that there is a big scam going on, we now find that all that investigation is on the basis of a non-existent FIR. Number four, if this judgment...
Dr. Singhvi, I must stop. Dr. Singhvi,
allow me to explain
what the court seems to be suggesting is procedural because it's based on a private complaint that was filed by Dr. Swami. But the judge observed that the Delhi Police's Economic Offences Wing has since registered an FIR in the matter, and therefore the ED can carry on the investigation based on that FIR.
So therefore, I was just coming to the point. You must first realize that for the last 3 to 4 years, you are going on something which is today being found to be without jurisdiction. The consequence, according to me in law, would be that all that investigation becomes null and void. Now, what will happen in the future will be for us to challenge. We don't know. Today, 2 weeks ago or 1 month ago, they have filed a new FIR. The new FIR is basically the same thing as the old with some few things added. Now, whether that will stand the scrutiny or not will have to be seen. It's open to all our challenges. Cognizance of that is a separate issue. My point is, how is it premature? That means all the hullabaloo you saw on your channels, all the newspaper leaks you saw on the newspapers, all the shouting from the rooftops you saw by the BJP and the government against National Herald, that was all a premature shouting. If that was not premature, why is our celebration premature? Today, it is...
So how does the courts... So if I may ask you, how do you believe that the court's refusal to take cognizance of the EC's charge sheet based, of course, on Dr. Swami's complaint validate your earlier arguments that you've been making about the absence of a predicate offence or the alleged procedural flaws in the National Herald case? Why do you believe this is a victory for you?
Please don't keep calling it procedural. That's your characterization, and it's a mischaracterization. It's highly substantive. Our case was what? That you had an ED barking up a tree for the last 3 or 4 years without the body of the main scheduled offence being there. That's a substantive issue. The first principle of PMLA is that you cannot have a tail, which is the ED consequential offence, wagging without the existence of a dog, which is a predicate offence, the FIR. Now, this court has found that there is no FIR in terms of a requirement of law under the PMLA Act. There has to be a police report, police complaint. There is none. Mr. Subramanian, Dr. Subramanian Swami started a private complaint, which most of us tend to forget. He himself got a stay of his own complaint and the proceedings before the magistrate. He got it stayed himself by the High Court. Now, there is nothing on which it could proceed yet. What did you hear politically and legally for the last 3 or 4 years? 56 hours of interrogation of Rahul Gandhi. Mr. Kharge and Madam Sonia Gandhi had hours. That was on what? On the basis of a non-existent FIR. And we are not entitled to tell you that this puts mud on the face of the ED. It makes them look foolish. Now, a month and a half ago, after 4 or 5 years of doing this, they tried to file another FIR, which is a rehash of the old with some very limited new facts. That will take its own course. We will deal with it. I'm sure we'll be able to point out equally
so you're seemingly suggesting
gaps.
You're seemingly
It's a major
suggesting this, according
substantive
to you, this is
flaw.
a classic case of the process being the punishment. You seem to be suggesting this is a classic case of the process being the punishment. The ED sources who are telling us saying, A, they are going to appeal against this lower court order, and they believe they still have substantial evidence, they claim, to prove money laundering.
So let me answer both your questions. It is certainly process being the punishment. That is the rule in most of these cases, because for the simple reason, Rajdeep, you and I know, the conviction rate in this is abysmally low. So everybody is going to be acquitted, but you harass them because the process is the punishment. That's putting it mildly. Secondly, they will of course appeal. Nobody can prevent their right to appeal, but we are talking as of today. As of today, they have mud on their face because they've been prosecuting. And why were they shouting so much? It is because politically it suits them to say this is a huge scam. Arey bhai, it was a huge scam. You didn't have a FIR on it. You were relying on a private complaint by someone who himself got his own proceeding stayed. Does the ED have to be taught some basic law? And certainly calling it procedural is nothing. That's just a characterization in a self-serving manner. It is a very substantive fatal flaw. Right from the famous case of Vijay Madanlal Choudhary, which is a basic case, it has been held that without the basic offence of an FIR, you can't have a PMLA offence. Now, I can tell you that this new FIR is also full of flaws, but I am not at the moment going to reveal to you our strategy or our decision about it. But to say that now everything is hunky-dory because last 4 years are washed off, lack of jurisdiction, the entire investigation goes. What were you investigating, Rajdeep? Your investigation corpus, let's say, is 10 volumes. That 10 volume is based on non-existent FIR. What is the value of that, evidentiary value of that?
Okay, let me leave it there, Dr. Singhvi. You've clearly given your reasons why you believe what's happened today is, to use your words, mud on the face of the Enforcement Directorate, and you seem to suggest it is certainly a vindication of the stand that you've taken. We'll wait and see how that plays out. But for now, for joining us, Dr. Singhvi, appreciate you joining me.